welcome and thank you to all of our brokers. We have over 230 brokers, which I think is about as many as Microsoft Teams allows us. So this is a fantastic turnout, and thank you so much for your time. And welcome to another iToO. So iToO and our Friday sessions are a way that iTOO is really just trying to keep in touch with our broker community, share with you some expert learnings, advice, and have a bit of social fun as well. And I think today is no different. Today we have two of our really best experts talking to you today. So firstly, I'd like to introduce Giselle Pereira, who is our product champion and head of commercial crime. And Giselle has certainly picked a very challenging line of business to head up and look after for iTOO. And for me, Giselle is one person that really sums up what it means to be an expert, because when it comes to underwriting a very difficult and challenging class like this, it really is about being an expert. And that expert means a deep understanding of each and every risk, but also a deep understanding of the commercial and relationships aspects that we have with our brokers. And I think that as iTOO, as Giselle said, we have managed to balance this difficult class and underwrite it correctly, but also be there to support to our brokers. So as a message to all of you from Giselle and iTOO, we really are here to do our best to support you in this difficult class of business. And Giselle is not going to be speaking today, but she is on the call, and we will take your questions after the presentation. I would like, Giselle, is there anything you want to say before we hand over to Willie?
No, thank you. Just thank you everyone for joining. I'm going to mute myself and turn my camera off during the presentation. However, I will turn myself back, the computer back on once Willie is done talking.
So Giselle, we look forward to you being turned on at the end of this presentation if Willie does a good job. And then I'd like to hand over to Willie Jansen van Rensburg. And in claims is the one thing that we really do sell as all insurance companies. It's been really interesting to see at this time during COVID-19, some of the claims in the hospitality sector, which has been certainly a very challenging class for insurers and clients. And I think it's just for me highlighted the importance of really understanding your policy and the cover and really getting into the detail of claims, because ultimately as insurers and as iTOO, that is what we sell. And at iTOO, we are really lucky to have a guy like Willie on our team who heads up our claims team, but is also happens to be an expert in this line of business, commercial crime. So Willie is going to be talking to you a bit today about commercial crime. And I'd like to ask you, if you do have any questions, please put them on the message group. And I'm going to hand over to Willie, and we look forward to hearing from you and chatting to you afterwards. So over to you, Willie, and thank you very much. And thanks to all of our brokers for joining us today.
Thank you, everybody. Justin, just to make sure you can hear me clearly.
We can hear you, and you're looking as good as ever. I'm going to mute my mic, Willie, but I will be here, and I will shout if there's anything I need to tell you.
Thank you. Right. Welcome, everybody. Imagine 10 years from now, you're sitting in front of your client. It's a new client that you've just landed, and you need to explain the uninsurable risks with your client. There's a new addition to the list. Lloyd's, you've tried everywhere, the local markets, nobody wants to touch it. And you need to explain why. In today's world, commercial crime is no doubt on the endangered list. The product is in danger of becoming uninsurable in South Africa. We can't do much about the crime itself, but what can we do? What can the insureds do? Well, for a start, we can look at the fraud triangle, where the insured companies what they can implement in order to mitigate and detect fraud and theft within the company. The first pillar of the fraud triangle is pressure. People who are up to their ears in debt, greed, illicit activities, such as gambling or drugs, life challenges. COVID-19 has brought that upon us. What can the insured do? Simple background checks, criminal checks, previous employment checks, that to a large extent assist to mitigate and prevent and to detect these losses. Lifestyle monitoring. Someone has been driving a small car, always now rock up with a Porsche at work. There's something wrong. Lifestyle monitoring is very important. Opportunity. Most of the theft and fraud within the companies is because there's the opportunity. Inadequate internal controls, no segregation of duties, or where management simply trust the employees too much. What can they do? Internal controls is important to implement, but not only to implement, to monitor and to enforce it. The employees must respect those internal controls. Proper segregation of duties. I cannot emphasize more that this, whether it's in the finance department or whether it's in the warehouse environment, segregation of duties is pivotal in order to either prevent losses or mitigate it. Last but not least is rationalization, where people think they don't get it paid enough, or where they in fact don't get it paid enough. Or, for example, again in the warehouse environment where they say everybody's doing it. Small items, everybody's stealing daily, and why shouldn't I also steal? What can we do? Well, the insured can start off by paying market-related salaries and introduce whistleblowing hotlines or similar programs. What can we as insurers do? We need to be able to try and get to remain this product insurable. So what can we do? In this hard cycle, I think we have a duty to remain underwriting this product strictly and to price it accordingly to remain profitable. That ultimately will assist. From a claims handling point of view, we also have a duty to ourselves, to the product, and to reinsurers to handle this, to handle the claims consistently, firmly within the policy coverage. However, always we try to do it with TCF in mind. On that score, we always want to be able to convey to the insured and to the broker why we've taken certain decisions. And on that, I'm glad to advise that we always are happy to share our factual reports from the loss adjusters, as well as legal opinions that we base our decisions on. It's much easier to diffuse a contentious claim if everybody is on the same page, at least in terms of the facts. So what can you as the broker do? First of all, ensure renewal information is correct and complete. Do not send half-completed proposal forms to the underwriters. The more information Giselle and her team, or any other insurer for that matter, has, the better they can underwrite it, the better they can price it. Make sure information is complete. Do not complete proposal forms yourself, at least without not confirming with the insured that the information is correct. Make sure the insured understands the relevance and importance of declarations. I'll touch on that later in my presentation, but if they, in terms of, for example, background checks, if they declare that they are doing background checks and they don't, there may be an issue at claim stage. Understand the basics of this product. I know some brokers, it's perceived to be a difficult product. It's not rocket science. The first step we need to take is just to start by reading the policy, asking questions. Make sure you understand the basics of the product, whether it's the theft or fraud section of the policy or the third-party computer fraud. At claim stage, don't argue for a claim that's clearly not covered or unsubstantiated. We understand we're in a difficult economic situation currently, and sometimes there are claims that is simply not covered, or the insured is simply not able to prove its claim. In many cases, the brokers then push for the claims to be paid regardless of this. We understand the pressures that you are on from your insured, but if we want this product to remain a viable product, we need to pay claims that's valid claims within the ambit of the policy. Last but not least, manage expectations. This will ensure that your client trusts you. This will ensure that they see the professional assistance you as the broker provide. So in terms of contentious aspects, know and understand what can go wrong. Know and understand that we need to work through a process to work through those aspects. This comes to my second part of the presentation where I'm going to address a few of these contentious aspects. The list in front of you is not exhaustive. There are probably twice as many aspects within a commercial crime claim that can become contentious. At least 8 out of 10 claims, in my experience, is contentious in either one or more ways. But we almost always are able to work through the issues and ensure a happy outcome for all parties, regardless of what it is. So the first one, date of discovery. So what's the significance of date of discovery? It's very important. First of all, it determines which policy period is triggered. In other words, it's the date of loss for this particular policy. Secondly, all losses after the date of discovery is excluded in all commercial crime policies. So it's very important to know what the date of discovery really means. Let's quickly go through what exactly it means. I'm going to read this quickly and then we'll move on. The date of discovery. Discovered means immediately, not later, immediately when the insured or any of its directors, officers, partners or trustees, managers, I'm highlighting managers, I'll come back to that, becomes aware of any active fact that gives reasonable grounds to believe that a loss has been suffered or may be incurred, even though the exact amount or details of the loss may not be known at the time. For the insured to understand when discovery is. It's very important for the insured to understand that the losses will be excluded after discovery. Sometimes they don't report claims because they don't know when the date of discovery or what the impact of date of discovery is. Make sure your client understands this. But probably one of the top 5 contentious points at claim stage is collusion. So collusion means any circumstance where 2 or more persons are concerned or implicated together and, very important now, materially assist each other in committing an act which give rise to a loss. So materially assist. So what is the importance of that? The policy covers a form of active collusion that materially assists, where there's a kingpin or where there's employees, the one open the door for the other one, they materially assist each other to commit the fraud, as opposed to a passive collusion. Now, an example of a passive collusion is if it's a free-for-all, again, let's use the warehouse environment where there's small but relatively high-value items. Everybody's stealing for their own account. Everybody knows everybody else is stealing, but they don't materially assist each other. That's a form of a passive collusion. The policy, however, requires an active form of collusion where they assist each other. So what's the significance of this? It's very significant. It determines whether there's more than one occurrence in terms of the policy, or put simply, is there more than one claim in terms of the policy? And if there is, there's obviously more than one deductible that's applicable in terms of the losses. Employee. We don't think that the definition of employee can become contentious at claim stage, but it can. Employee means any natural person, not an entity, natural person who is in the regular service of the insured, whom the insured compensates by payment of salary, wages or commissions, and whom the insured has the right to govern, control and direct in the performance of such services. So in general, as long as all the employee numbers are declared to underwriters, there's no issue. There's also some automatic inclusions within the definition of employee, as, for example, volunteers, part-time employees, and directors in their capacity as employees. So for those, as long as the insured has declared them, all is fine. However, there are certain individuals that need to be specifically declared, and they can't just be included in the numbers that's been submitted to underwriters. For example, hired or seconded or external contractors. You need to specifically declare them as, for example, external contractors to the underwriter, so that the underwriter have the opportunity to decide whether they want to cover those individuals or not. Next one, the unidentifiable employee extension. Now this is again, I'm using the warehouse environment because lately there's been a lot of claims in that component. Quickly to read the definition. If a loss is alleged to have been caused by fraud or dishonesty of any employees and the insured is unable to designate the specific employee causing the loss, the insured's claim shall not be invalidated by their inability to do so. But, again, very important, provided that the insured is able to furnish evidence to prove to the reasonable satisfaction that the company, that the loss in fact was due to theft of those employees. So what does this mean? This means the insured must still prove that it must have been employees, even though they can't identify the individual or the group of employees. They must, to an extent, they must rule out third-party theft, for example, theft by public or security services or other external parties. Once they've done that, and it's now on a balance of probability proven that it must have been employees, there's an additional onus on the insured to prove that how many claims, how many occurrences has taken place. And again, as I've explained previously, the importance of that is it determines how many deductibles are applicable and also in terms of the limit. Extended cover for past employees. There's a misperception that an employee must still be employed by the company at the time the loss is discovered. That is not true. Our policy provides that for a period of 90 days after the employment has ceased, that the specific individual will still be regarded as an employee in terms of the policy. And again, this simply means that if this person managed to steal or commit fraud before his or her employment has been terminated, if they manage to continue to steal for a period of 90 days, those losses will be included in the claim. Non-disclosure, misrepresentation. No doubt one of the top contentious aspects when it gets to claim stage. In short, any material fact or circumstance or alteration in the risk must be disclosed to insurers or underwriters prior to inception of the policy, or at renewal, or even during the currency of the policy. Sometimes the misrepresentation or disclosure is not material, but very often it is. For example, criminal checks or previous employment checks. If the insured confirm and declare that criminal checks are being conducted prior to employment and they don't, and there's a claim where this could have been, they would not have employed this person had they known he had a criminal or she had a criminal record. It's very material in terms of this policy. Also, independent stock takes versus internal stock takes. Very often the insureds confirm that independent stock takes are being conducted, but at claim stage you found that only internal stock takes were conducted. As an example, a warehouse manager marks his own work, he submits the stock takes. So internal stock takes does not necessarily mean independent stock takes. It must at the very least be a manager from a different warehouse or from a different company or from an audit company to conduct the stock takes. Very important. The last one is self-explanatory, new business activities. If the insured confirmed one or two types of businesses, and during the course of the financial period or the policy period, they go into a vastly different type of business, very important to declare that to insurers because it changes the risk. Losses discovered as stock take. There's a perception that this is not covered. So we put an endorsement on our policy, but it's not true. It's not that it's not covered. It simply means that in terms of the merits, we only polygraphs are submitted as the sole evidence. That is not acceptable on its own. In terms of the quantum, if there's only a stock take inventory provided as proof of the quantum, that in itself is not acceptable. But if the insured is able to provide some sort of direct evidence to prove that in terms of the modus operandi, the loss is linked to employee theft, the policy will cover that. And again, the better the systems and procedures implemented within the insured's business, the easier it is to prove its claim. So for now, help us keep this rhino insurable. Know your client. Make sure you know your client's needs. Know your product. Make sure you know exactly what is covered, what is not covered. Understand and manage these contentious aspects. If in doubt, ask iTOO. Short and sweet, thank you.
Thank you so much, Willie, for that presentation and discussion. And we've often found that the best part of these presentations and the learnings come from a question and answer discussion afterwards. So if you do have any questions, please can you put them on the message group, and I will be sure to ask them to Willie and to Giselle. So Willie and Giselle, we have one question from Dave Hopcroft. And he says, if a claim turns out to actually be multiple occurrences, what is the impact of the reinstatement sum insured clause on such claims? So in multiple occurrences, what is the impact on reinstatement?
Well, first of all, if the multiple claims or multiple occurrences, if it's more than the limit, and the reinstatement is necessary, it depends on whether it's automatic reinstatement or not. If it is, the limit will still simply be reinstated in terms of the claim. We normally, if there are more than one claim, as soon as the claim is paid, that will erode the limit. Dave, I hope that answers your question. Perfect.
So I think it does. And if there are any other questions, please ask on the group, and once the group gets a bit smaller, we will ask if you want to come on your video, and if you do want to put on your microphone and ask a question, we'd love to hear from you as well. Here's a question maybe for Giselle. What are the types of industries that you see as the biggest problem in commercial crime? So which are the risks that really scare you as an underwriter? And is there a way that we can underwrite these risks? What can we do to make these better risks?
So thank you, Justin. I think everything at the moment from a commercial crime perspective is scary, from office risk to manufacturing risk to a warehousing risk. At the moment, as Willie said, we're seeing a lot of notifications come out of warehousing and distribution risks and your logistical risks. And then, yeah, so for us as underwriters, I think it's just important to scrutinize that proposal form and do our research on the specific industry. And that's why Willie said it's very important for you as the broker to ensure that the client is providing accurate information on that proposal form, so that when we're underwriting, we can look at things such as stock on hand, the maximum electronic transaction that they're doing once off, the turnover, how many risk locations they operate from, segregation of duties. So when we are underwriting the risk, we can look at those factors and apply the applicable deductibles in relation to those factors. And those are just some of the factors that we take into account when we do underwrite a risk. So,
Jason, I can maybe just add there that the mining industry, construction, and the fast-moving consumer goods sector, those three are prone to more claims and bigger losses.
Great stuff. Willie, we've got another question here from John Kirby, so maybe you can answer this one. How does one quantify a loss if there are outside third parties involved and active collusion? How do you differentiate and divide up the loss between the guilty parties?
So it doesn't matter how many external parties are involved. If the insured, if one of the employees collude with third parties, it's regarded as one claim. So hope it answers your question. It's with regards to the different limits of or the different deductibles. It is important whether the employees within the company collude or not.
So to all of our brokers listening as well, I want to be a little bit cheeky as well. It's a week to go until 1 July. I know it's a busy month for all of you. And I'd really like all of you to ask you all for your support, particularly those of you that have been listening in. It's been great to connect with you, and we'd really want your support. So I'd like to say to you that our whole team is on call and ready to take your support and to help you with some of these risks. But maybe, Giselle, could you give a little bit of an outline as to what is our approach to underwriting commercial crime and how we look at it with supporting business?
Sure. So as we said at the beginning, it is a strained line, but we've committed to our brokers that we would continue writing this class of business. However, one of our minimums we require is we won't write comp crime on a standalone basis and would require one or more supporting lines of business. So we won't bind comp crime alone. And then when we underwrite, we obviously apply the applicable deductibles necessary to the risk, but we do this hand in hand with the client. And then where we are seeing requests for higher limits, we are offering lead lines, and then it's for you, the broker, to go seek an option to get an option as a co-insurer to come on board with us. But obviously those lines of communication remain open between ourselves and you as the broker.
Great stuff. So maybe I'm playing a bit of table tennis between Willie and Giselle here. So we're getting some cool questions coming in. So here's a question from Elaine Nathan. So thanks. This is a really good question and one that you probably want to listen to because it's relevant for now. So Willie, Elaine says working from home and the possible new exposures is going to further impact commercial crime viability underwriting. Safe collusion is to commit fraud, internal theft. It would be easier to hide if employers are working from home. So, Willie, maybe if you could just give some views on why commercial crime cover is so important now with us working from home, and have you seen any trends?
Yeah, so first of all, we're starting to see trends of claims that come through as a result of people working from home. Obviously, for example, in terms of the finances, where there's normally deal signatures or a deal authorization, where this is now overlooked in the warehouse environment, where people simply was not at work, and where there's only one or two employees responsible for looking after those the stock. So yes, in terms of COVID, we do foresee an uptake in claims. From a risk management point of view, insureds must up their game in terms of people working from home. Systems, very important to try and prevent people taking liberties at home. via the systems.
I think
Great
if I
stuff.
can quickly just add to that, please. Where we are receiving requests for new business along with our renewal submissions, we are asking that an additional supplementary proposal form be completed, and it's a one-pager just focusing around questions relating to COVID and work from home and how the client is dealing with that, so that if they aren't putting in necessary measures, we can then obviously advise how they are to do so and apply any necessary subjectivities or warranties to the policy.
Great stuff. Thank you, Giselle. So here's another interesting question from Mike. So thank you, Mike, for this question, and I'll maybe put it open to Giselle and Willie to comment. How closely is the cover under commercial crime policy when the insured holds funds in a trust to the liability for employee dishonesty fraud under a PI policy? You got that, Willie or Giselle?
Just repeat that again.
So how closely associated is the cover under commercial crime policy to the liability for employee dishonesty or fraud under PI policy? And that's particularly when the insured hold funds under trust. So it's really the difference between commercial crime and dishonesty fraud under PI policy.
Yeah, so the commercial crime policy covers you for a direct financial loss where you are responsible for funds of third parties. So the simplest in my view to distinguish is whether you need to replace those funds regardless of whether it was stolen due to your negligence or not. So in terms of the PI policy, it would cover you for your legal liability following fraud and dishonesty. So it overlaps to some extent, but the one would only cover you, the PI policy would only cover you if you are legally liable for those funds, where as opposed to the commercial crime policy covers you when you've suffered a direct financial loss, when you need to replace that money regardless of who has stolen it.
Great, thank you, Willie. So here's another question, which I think is a really key one for me at the moment in the industry. It's around retroactive date. So what is an appropriate retroactive date for commercial crime? And maybe you want to talk a little bit about underwriter's stance on retroactive date. I mean, I've certainly seen, in some cases, these larger claims go back over a number of years. So what is iTOO's stance on retroactive date, and what should brokers be aware of when advising their clients about a retroactive date?
All right, so I think from an underwriting perspective, for new business, the ideal situation is to take on that business with retro as inception. I think it's starting from a clean slate, because you don't know even though your clients are saying there's been no incidents, no circumstances in the last 5 years, you're not sure what may be beyond that 5 years. Where we're seeing submissions come in asking for retroactive dates more than 5 to 10 years, I think the most we're willing to do for new business, if we're not going to get the inception, is 24 months. But then we would offer that as a 24-month rolling retroactive date, instead of the 24 months that then just becomes 10 years. And then, in terms of your renewals, that will obviously stay as is what the policy incepted as when we took it on. Willie, I'm not sure if you need to add anything to that or would like to add anything to that.
Yeah, I think there's not a hard and fast rule as to what the retro date should be from a broker perspective. Obviously, you need to try and get the retroactive date to be as far back as possible. But given the hard cycle we are in, you may get pushback from our underwriters. But if the insured understands that, and they understand that they only covered from a certain point in terms of the retro date, if those systems and procedures I've alluded to earlier, if that's in place, it should not necessarily be a problem to accept a shorter retro date.
Great stuff. I think those are all of the questions that we have so far. So I think that really brings us to the end of the presentation. I would really like to say to the brokers that are listening in, thank you very much for your support. We really appreciate it. And we appreciate even more some of your support in this last week of June before July. It's our iTOO's financial year. So if you think that iTOO's done a good job in underwriting and keeping in touch and keeping up expert service always, now is the time that we would really appreciate your support. And as I'm trying to end off, I'm seeing there are a couple of questions coming in. So we've got some time. So let's answer some other questions. So Jerome Schofield, thank you for your question. And maybe we can ask this to Willie. How does iTOO define theft? What if an employee borrows funds? Willie, have you had that scenario before?
Yeah, well, theft is defined to, you have to have intent to misappropriate or steal funds or property of the insured. If it's borrowed, it will come down, and if it turns out that it borrowed it without consent, or with the intention to give it back, it would probably still be regarded as theft. It all comes down to then the intention of that person's actions. Does it answer your question, Justin?
For that. Yeah, I think it does. But I mean, I guess if it was borrowed, we paid back, we would accept that as part of a process, and there probably wouldn't ultimately be a claim. But for me, I think at the end of the day, if it's not paid back, then it certainly does become viewed as theft.
Yeah, very often there's clear documentation or paper trail that show that specific funds or that the property or money was not borrowed, as so to speak. But if someone without permission borrow money or property, all with the intention to give it back, it sometimes gets difficult to prove that it was in fact theft. But most of the times it is. Yes, Jerome.
I'm referring to a case where, when confronted with the police and an investigation and the possibility of going to jail, the employee said, well, he was in an emergency situation and he needed some funds. He was going to pay it back. But a few months had gone by, and the insurers turned around and said, well, look, obviously this wasn't theft. See, he was going to pay it back.
It's difficult to without knowing all the facts, but that clearly to me shows that he now decided suddenly he's going to give the property back. So turn it into a loan. So I'm with you on that one. That's theft to me.
Thank you. That's good to know.
Good stuff. Thank you so much, Jerome. Nice to have you with us, and thanks for the great question. And if there are any other brokers, if you want to put on your video or your microphone and ask us a question or say cheers, it would be lovely to hear from you. And otherwise, we look forward to and thank you for your support in this last week of June. And Willie and Giselle are certainly there to help in commercial crime, as well as all of our other lines of business. So thank you very much, guys.
Thank you. Justin, can I just jump in and answer Vanessa Branco's question? She asked, how does a commercial crime policy differ from an FG policy? So one is FG, one is CC. The acronyms sound very different, but actually they're one of the same thing. However, one of the only differences is that a crime policy includes a third insuring clause of third-party computer fraud, whereas your FG policy doesn't include that, and is usually just a very narrow, watered-down extension on a commercial policy.
Great stuff. Thanks, Giselle. So, I mean, I think advice probably there in these sort of times would be to take out a proper commercial crime policy rather than an FG policy that's included in your multi-mark type policy wording. So my advice would be to take out a proper commercial crime policy rather than an FG policy, although the cover is similar. And for me, again, the message is expert. When it comes to complicated claim, do you want to be dealing with a commercial insurer who's used to dealing with motor and property, or do you want to be dealing with experts like Willie or Giselle, who this is all that they do and they really have a deep understanding of the cover? So deal with the experts would be my advice. Yeah, thanks for that, Giselle.
Pleasure.
Great stuff. So it would be lovely to hear from any brokers. If you want to say cheers or ask any questions, we're wrapping up, so you're free to leave. It would be great if you ask us questions or say cheers.
Thanks, guys. Cheers.
Thank
Cheers,
you
guys.
so much. Thank
Guys.
you.
Willie, if you could maybe just perhaps answer Mike's question. What has iTOO seen as a success rate in frauds committed and claims paid under the policy and the criminals brought to book?
So in terms of percentages, I would. It's very difficult to give you a percentage of how much recoveries we are in fact are successful in, but we do drive recoveries very hard. That's one of the professionals that we use from that point of view, drive recoveries very hard, and we do, as far as it makes economic sense, we do make sure that those individuals land up in and being convicted in a criminal court. We also pursue either civil or criminal routes in order to get the money back. So from a success rate, I would say anything between 30 and 50% in terms of recoveries, but in many of the cases, the money has been long gone. It's either been gambled away or drug abuse, or it's already spent. So it's sometimes difficult to get the money back.
Perfect. Thank you, Willie.
Rodney, another question. Let's see.
Yes. Thank you very much. Thanks very much for taking my question. I've had the odd case where, in trying to market either an FG or a commercial crime policy to our clients, is that they're sometimes reluctant to take the insurance because they feel that the insurer will take over the recovery proceedings, and it may not be the methodology adopted by the insurers is, often a lot less sympathetic than the employer would, the line that the employer would take. So the employer often would try and maybe negotiate some kind of repayment of any debt that's arisen as a result of some sort of fraudulent activity, rather than land up putting someone behind bars who's got a family to support and that type of thing. How do you respond to a client that, may feel that the recovery proceedings undertaken by the insurer are too harsh?
So first of all, I don't think that should be a reason not to buy a commercial crime cover. They should be, if the insurer has paid in terms of their subrogation rights, it's obviously within our rights to pursue a recovery. However, we do take sometimes those considerations or those facts into consideration, where there is a family, where the person are willing or is able to repay the money. And from a plea bargain point of view, we very often negotiate with the defalcator's attorneys for a lesser sentence, or maybe a suspended sentence if it's a first offence. So to answer your question, we would be open to negotiate and with the insured if there's a specific case that they feel very strong on.
Okay, thank you very much.